Mr. Speaker, and I want to thank my colleague from Calgary Nose Hill for her passionate speech. Well, here we are again on the 11th hour attempting to send this bill, S-3, back to the Senate for royal assent prior to the December 22nd, 2017 deadline. I guess we call this flying by the seat of our pants legislation. There is a court-imposed deadline, so just get it done regardless. We have talked about that in the House most of the day. So Bill S-3 was tabled in response to a Superior Court of Quebec decision, Deschanel against Canada, 2015, and other clearly identified issues. The court found that several aspects of Indian registration under the Indian Act violate the Charter of Rights and Freedoms because there was differences between how status was passed down from First Nation women compared to First Nation men. These provisions were struck down, and Parliament was given a limited time to pass the alternatives. The new deadline to pass legislative changes, as we've talked about, after 2 extensions is next month, December 22nd. The court has indicated they have no interest at all, and we've talked about this, in giving the Liberal government even a 3rd extension. So when Bill S-3 was first brought to the Senate about a year ago, in fact, exactly a year ago this month, the government sought to remedy the situation to bring it back to 1951. However, several independent senators proposed adding what is known as the 6-1A all-the-way approach. This amendment would have all Indians registered as 6-1A with equal rights and entitlements regardless of matrilineal or patrilineal descendants back to 1869. The government, though, rejected those proposals. So after rejecting it, mid-June, June 21st of this year, the Liberal government undertook behind-the-scenes consultations with senators over the summer months to seek consensus around an alternative proposal. Resulting proposal changes were tabled in the Senate just earlier this month, November 7th, and would come into force in 2 stages. The first one we've talked about, the aspects of the bill passed by the House of Commons in June would come into effect by the court-imposed deadline of December 22nd. Secondly, newly added clauses which would extend the proposed remedies of sex-based inequities in the Indian Act back to 1869 would not be enforced until after a consultation process with Indigenous peoples on how to proceed. That is the million-dollar question. There's no date has been given when the process would begin or even conclude. Let's go back now. We've talked a lot about this bill, but what the previous Conservative government did. A long history of supporting gender equity for First Nation women. As a government, we introduced the Family Homes on Reserves and Matrimonial Interests, or Rights Act from 2013, which offers a balanced and effective solution to a long-standing injustice and legislative gap that affects people living on reserves, particularly, Mr. Speaker, women and children. As a result, many of the legal rights and the remedies relating to matrimonial interests in the family home that are available off reserves in the context of relationship breakdown or a death of a spouse or even a common law partner or family violence are now available to individuals living on reserve. The former Conservative government also reintroduced legislation to guarantee to people living on reserve the same protections that other Canadians enjoy under the Canadian Human Rights Act, which came into law June 18th of 2008. We also passed Bill C-3, Gender Equality in Indian Registration Act from 2010, in response to Vicker versus Canada 2009. Bill C-3 allowed for the eligible grandchildren or women who lost status as a result of marrying non-Indian men be entitled to registration if they or their siblings were born on or after September 4th of 1951. It should be noted that the Liberals, including the current Minister of Crown Indigenous Relations and Northern Affairs, actually voted against the Family Homes on Reserves and Matrimonial Interests or Rights Act from 2013, which was introduced and, by the way, passed by the former Conservative government. It should also be noted that the legislation that made the Human Rights Act apply on reserve, Conservatives tabled this legislation, and then all parties worked together to pass this legislation. So essentially, prior to the Bill C-3, the Gender Equity in Indian Registration Act of 2010 and the proposed changes in Bill S-3, Indian status was passed down to the next generation from the father, but not through the mother. Therefore, if a First Nation male had children with a non-First Nation female, his status would be passed down, but not vice versa. And that's why we're talking about here today in the House, Mr. Speaker. As we continue on, not long ago, I had a call this week from a friend in Saskatchewan, and we were talking. He's a Cree First Nation. He is unequivocally in favor of this bill, S-3. He has a status Indian niece who is married to a man from Honduras. And not long ago, Mr. Speaker, they celebrated the birth of their first child. My friend said he is the cutest little Honduran Indian that you've ever seen. Well, perhaps with this passage of the bill S-3, that description should change to he is the cutest little Indian Honduran you have ever seen, and wouldn't that be nice? And I think that's what we're headed for after December 22nd. My friend, though, also had a very good idea that he passed along with me earlier this week, and it's regarding the 6-1A all-the-way approach back to 1869. He suggested giving non-status Indigenous people up to 10 years to get their genealogy sorted out. Now, that seems like a long time. I know 10 years is. However, it could be a gradual process. Some people will have their family trees available now, while others will have to dig around and find the right roots to them and the proof to them. I think this is a pretty excellent idea that he came up with, though. It will also give the department an opportunity to work through these changes and prepare for the financial implications that they will entail. At this point, it is exactly unknown how many Canadians would become eligible or even apply to register, and what financial implications would be on the Canadian taxpayer. We have no idea whatsoever. Could be 200,000, could be 400,000. We don't know. It depends how far back people go in the tree. So I think we need some time to figure this out. I don't know if it would have any implications for roughly 1/2 of my province's Indigenous population. And finally, Mr. Speaker, we, the official opposition, as we've stated all day here in the House, support this Bill S-3 at second and third readings because it does contain several necessary changes to the Indian Act toward greater gender equality and are the next steps beyond amendments made by the former Conservative government with this Bill C-3 back in 2010. What I do not agree with is this flying by the seat of your pants method of legislating by this government. They've had more than enough time to table a good, clean piece of legislation that everyone could get on board with and get it passed. Instead, they have chose a path that they knew would encounter resistance and delays, especially in the Senate. I do not believe we can pass or please all of the people all of the time, but we as legislators, we have an obligation to please as many Canadians as possible all of the time. And that is our duty, Mr. Speaker, and it really shouldn't be muddied. But we're going to support this bill, S-3. And Mr. Speaker, my time has run out. I just wanted to say on behalf of the people of Saskatchewan, they're excited about this bill. They're hoping it does pass, and then we can move forward as of December 22nd. Thank you very much.